Good evening and welcome to our webinar on the Renters' Rights Act and an update on what is going to be going on from the budget last week, and also what making tax digital will mean for landlords. Really good team to come and talk with you tonight, and what we'll do is we'll take any questions at the end collectively, so we'll make sure we go through all of those. But do type your questions in. You'll see a Q&A button there. If you type those in, then we'll go through the questions at the end and try and get through as many of those as we possibly can. If we don't get round to asking you a question, then we will automatically get emailed all of those, and we will get back to you in the next couple of days with answers to your questions. Also worth mentioning that you'll receive a copy of the recording about this sort of time tomorrow night. So if you wanted to listen back to anything or to double check something we've said, then you'll be able to do that there. So without further ado, we're going to get first of all, the Renters' Rights Act. And as I say, we're talking about that. We're talking about making tax digital with a local accountant, and also talking about what last week's budget meant for those of us from a landlord perspective. So diving straight into the Renters' Rights Act, the government have helpfully broken this down into phases and stages. We've got phase one and phase two. Before phase one, there's something kicking off as a special Christmas gift on the 27th of December. So this is even before stage one comes in. And this is about investigations. Now, I don't wish to ruin anyone's Christmas, and please don't panic. In theory, what this means is from the 27th of December, local authorities will suddenly be given much wider ranging investigation. So they can seek information from landlords or agents, and they can enter into a premises in order to obtain documentation. So in theory, the day after Boxing Day, they can come to our offices. Are we open 27th? I can't remember. Or even your home if you're a self-managing landlord, and asked for X, Y, and Z in support of a property if there's been some sort of issue. The reality is that is exceptionally unlikely, I think, particularly in Oxfordshire. But you know, the people doing this investigation work will also be on their Christmas breaks, and of course they will need to go away and find out about properties before they launch an investigation anyway. So I shouldn't panic. This is theoretical, but this does come in from the 27th of December, and they do have powers, as I say, to enter properties and seize documents. But I think it's exceptionally unlikely, as I said, that we will see anything from them. So what really starts is fortuitously 5 months from today, the 1st of May 2026, and that will see the abolition of Section 21 notices. So you won't be able to issue a Section 21 notice from that date. It also means that every tenancy that either starts from then or is already an assured short hold tenancy will become an assured periodic tenancy. And that will change the way in which you obtain possession, and Joy will come and talk to us about that in a bit more detail in a moment. It will also limit rent increases and the mechanism for doing that. We'll also see a ban on rental bidding, so tenants won't be able to offer over the asking rent, nor will they be able to pay their rents in advance. It'll also make discrimination illegal, and Grace will come and talk to us about that and what that means for landlords who are advertising their properties. And there are changes around consideration of pets in lets as well. I'm glad I got that the right way around. And lastly, there's some stuff around strengthening enforcement, the size of the fines that can be levied, and also around rent repayment orders. That's what RRO stands for, rent repayment orders. And that's the mechanism for a judge to say to a landlord, unlucky, you've got to pay significant sums of rent back to the tenant for some sort of infraction. So those are the key changes that are going to affect us in phase one, and phase one comes in on the 1st of May next year. Phase two is usefully split into two stages. Stage one will see a regional rollout of the database. This is the database that is mandatory for all landlords. There will be an annual registration for it. You will undoubtedly have to pay for it, although we don't yet know how much. And it will contain key details about the landlord, so contact details, name, who the owner is, and key safety information as well around, you know, the gas safety, the electrical installation condition report, the electrical safety report, for want of a better term. That will all be within that database, and we don't have a date for that yet. It's just late 2026. And then stage 2 of phase 2 will be the private rented sector ombudsman. And they envisage that will be coming in 2028. Once again, there'll be a charge levied for that. We don't know how much because we don't even know who the ombudsman will be yet. And as I say, that is predicated on stage 1 being rolled out successfully first, i.e. the database. Because you've got to have the database in order to know who the landlords are to get them to register for an ombudsman. Clear as mud. Now, I hope that makes sense. And then looking way out into the future a bit more is phase 3. And Grace will be talking to us about that again in a moment. But that is around a new decent homes standard. And rather confusingly, they've said that will be in 2035 or 2037. Quite what's happening in 2036, I can't tell you, but it won't be then. It'll be 2035 or 2037. We've heard a little bit more about minimum energy efficiency standards. That's MEES, and we'll cover that in more detail. And you probably heard some stuff about AWAB's law, the mold, damp and mildew, and that being implemented already in the social sector and that being brought into the private rental sector. So those really are the key timeframes around the Renters' Rights Act and what you need to know that is coming down the tunnel towards you as landlords. And the key date really, notwithstanding the 27th of December, is the 1st of May next year, when the majority of things that are materially going to affect how we operate as landlords come into effect. So without further ado, I want to get into the meat of this, and I'm delighted to be joined by Jason Wicks from Parkers in Chinner. Jason is an exceptional sales agent at the other end of Oxfordshire, and he's going to be talking to us initially about selling your rental property, in that how can you do that under this new regime, but more importantly, first of all, is why would you consider selling in the first place, Jason? So tell us about that.
Yeah, thanks, Brennan. I think the big question that I seem to get asked a lot at the moment from landlords is the panic around, can I sell my property? Will I be able to sell my property? And therefore, should you sell your property? And I think the number one thing to sort of take away at the moment is you will be able to sell your property when these changes come through. Come the 1st of May, there absolutely will be a mechanism in place if your circumstances change and you want to either move back into the property or if you want to sell the property. So don't panic. There's no need to panic. There's no need to do anything knee-jerk, and sell your property, take stock, and if it's not the decision to be making at the moment, there is no need to sell your property.
Okay.
And I think the key thing to understand, sort of as a long-term investment, rental properties as a long-term investment are still set to be, a fantastic, investment long-term. Yields are on the rise. Capital growth is great in the areas that we certainly work in. So with the ability to still sell your property in the future, my advice would be not to panic and take stock of your situation.
Yeah, I mean, we've seen some really strong rental growth, I think, in Oxfordshire in particular.
Yeah.
Whitney was referenced by Rightmove in their report back end of last year as having one of the fastest growing rents in the country. And I think that's true, across Oxfordshire. So we have seen landlords selling up, I think, from a combination of factors. But what that does, bearing in mind that demand for rental properties is growing, if the supply is tightening, then that's only going to put rents in one direction, isn't it? So
100%. We're seeing it month on month, huge shift in supply. And I don't really see that changing. So for landlords that want to stick with it and have a long-term strategy, then it's still a really good investment for the long term.
Brilliant. And the mechanism, should a landlord then say, okay, do you know what, for whatever reason, I'm out, it's time for me to sell just because that's my life plan, or whatever the reason might be.
Yep.
There is a new ground under Section 8, isn't there, that they can use under this? So
that's right. Yeah. So the new ground effectively means that you have the ability to sell your home, and the structure of that, a tenant has to live in the property for at least 12 months. Mm-hmm. And from 8 months of that tenancy, you can issue a Section 8, Ground 1A.
1A, right, okay.
1A. And that is 4 months notice for the tenant to vacate. So from month 8, you can issue 4 months notice to vacate. And from that point, once the tenant vacates, you are then free to sell your property.
And I think the key thing there is, if you are going to sell a rental property in the future, then it'll be far more important to work with an agent that fully understands both sales and lettings, because the two are going to go hand in glove, and that's really important so that you don't end up with void periods or penalties, under this new Renters' Rights Act regime.
Yeah, there's definitely a lot more to consider now. It's no longer put it on the market and see what happens. You need to be really clear in your plans, and if selling is the plan, then you're absolutely right. You need to have a professional estate agent that works through that, because the other factor that is sort of within the new strategy is if you give the notice for selling your property, you have to actively try and sell your property for at least 12 months before you could then look to relet the property. So you can't use it as an excuse to get a tenant out. If you're selling,
it's not a new Section 21.
It's not a new Section 21. If you're selling your property, you're selling your property, and you need to have a good strategy to exit that plan.
So if you do change your mind and decide subsequently you don't want to sell your property, where does that leave you?
It leaves you in a situation where you're going to have a property empty for 12 months. So you need to have a clear plan, a motivated estate agent, and really only be selling if it's absolutely necessary. Because if you decide you don't want to do it, or if the market's not in your favour, you will have to have a property sat for a year, and that is something you've got to bear in mind.
So I think you've got to be really, really confident that's what you want to do, and I think the best way to explore that is probably to have a meeting, maybe a couple of meetings with your accountant and your agent to explore what the future of the market looks like, what the pros and cons are, so that effectively you can make an informed decision about the right way to go.
100%. Yeah, exactly.
Okay, and I suppose closing thought from you before we dive into a bit more of the detail here is it still a good idea to sell with all these changing happening with landlords? Because let's face it, landlords are pretty fed up with, I think, constant rule changes, and of course the budget, which we come on to later. Should landlords stick or twist going forwards?
I think if you're looking at it still from a long-term perspective, then I think having money in an investment property is still absolutely a fantastic long-term strategy. So don't feel the need to panic and sell up. When we talk about supply and demand problems, increase in yields, capital growth, there is no need to sell, in my opinion.
Jason, brilliant. Thank you. I'm sure we'll drag you back to the Q&A in a minute, but I'm just going to put on a poll for, so we're trying to keep this interactive while we're changing the talk is over. If I could please just ask you all to have a quick think about this question that's on the screen in front of you now, and if you get a chance to just pop you only get to answer once, but if you could please just have a click on there for me and let us know what your thoughts are based on what we've been talking about so far. That would be really helpful. And while that's going on, I've been joined by Joy Henning, the lettings director of Parkers Whitney, and the queen of compliance, who is going to be taking us through in a bit more detail what some of these changes around the Renters' Rights Act actually mean. And I suppose, Joy, my first question from a landlord's perspective is, will I still be able to get possession of my property once the Renters' Rights Act comes in on the 1st of May?
Yes, you will. And the government's been really clear in saying that is still an option, and that is still something a landlord can do. It's just the mechanism for doing it will be different. We know that Section 21 is what we've used up till now, and that's been a great mechanism because you haven't had to provide any proof or evidence of the reason why you want the property back. The actual grounds that we're talking about tonight, these actually all exist already. It's just we haven't tended to use them because they're complicated, they're complex, you've got to evidence it, you've got to go to court to do it. So Section 21, which doesn't specify a ground, obviously that's not going to be used anymore. But using the new notices, so long as you have the evidence, you can still do it. Okay,
well, that's reassuring then. All right. And if I've issued a Section 21 notice before the 1st of May of next year, is that still valid when this comes in?
Absolutely, yes, it is. So don't panic. What they don't want is sort of a cliff edge scenario where everyone's panicking. You can still issue Section 21 notices, you can still do rent increases, you can still renew your tenancies right up until the 1st of May. You've just got to bear in mind the legal timeframes involved in all the stuff that you're doing. So, for example, if you issue a Section 21 notice, you need to make sure that you've done everything on the other side before the 31st of July.
Okay, so we can still work with those notices issued up to that date.
Absolutely.
That's useful. And if I now sort of put on my worst case scenario hat, and we're in this new regime after the 1st of May of 2026, and we've got a tenant that's displaying antisocial behaviour. We can no longer issue a Section 21, which would have been the easy thing to do at this point. So what do we do?
Yeah, okay. So there are certain reasons that you can get possession back, and the government split them into mandatory and discretionary grounds. And one of the mandatory grounds is antisocial and criminal behaviour. And that means that if your tenant has been convicted of a crime, you can get your property back. The notice on that is actually really short. What you can't do is go to the courts and say, well, my tenant's been displaying bad behaviour, they've been upsetting the neighbours, because that is a discretionary ground. And we can see a real shift now going forward in evidence-based possession. And this is why, as an agent, we are particularly skilled at this, because we can document everything that we do and we can evidence it. So if you were to go to court for antisocial behaviour, for example, you'd have to prove incidences of that occurring. You'd need to prove that you've actually spoken with your tenant to try and resolve the situation before it gets to court. And only at that point, if you've got enough evidence, will the judge even look at it. So when you're going to court, you've got to be very clear, is this a mandatory ground? So if I get the evidence together, is the judge going to give me possession, or do I need to build a case?
Okay, that's clear, thank you. There's also been a lot of talk around ombudsmans and compliance databases and all this sort of stuff. I mean, are they one and the same thing? A landlord's going to have to do all that? If I'm a landlord, what do I need to do now to make sure that I'm in the government's good books?
Okay, well, start getting your house in order. And again, we're talking evidence and certification and compliance. But what's happening is the two are getting sort of merged into one. And as you explained earlier, they're two very separate things, the ombudsman and the database. So don't get confused by getting the two. And you will, as you said before, still need to be members of those bodies, both as landlords, even if you have an agent.
Right, okay. And how much is it going to cost me? Do you know?
We don't know. And the paperwork's quite vague. So there will be a cost. They said it's not going to be huge. We'll just have to wait and see.
All right. We've spoken about antisocial behaviour, and hopefully that's towards the sort of the far end of the naughty spectrum. What about rent arrears? How are we going to deal with that under this new regime, and how does that change?
Yeah, of course. So rent arrears, again, is a mandatory ground. And this is one of the biggest changes. And this is where, as agents, we are focusing our sort of planning to mitigate any risks from this new legislation. So just to quickly recap, at the moment, if your tenant is 2 months in arrears, you can give 2 weeks notice to them and go to court for possession. That's going to change. And it's going to change to now 3 months, so a full 3 months in arrears, and then you need to give 4 weeks notice. The reason the government has done this is to give tenants the opportunity to sort of get themselves sorted out. Maybe if they've just lost their job and they've got a cash flow problem. As agents, what we will know that it builds up so quickly, 1,000, 2,000, before they know it, they've got £5,000 worth of rent to pay back. And they just really can't get out of that hole. So we're just concerned that if that happens, so you're looking at 4 months, 5, 6 months before you get in front of the courts, you've got such a big build-up of rent arrears, plus your legal costs. How are you going to do that?
Yeah, I mean, that's a worry. I think the average rent in Oxfordshire is just over £1,500 a month. So, you know, a year's worth of rent is therefore £18,000 plus any legal costs, and that's assuming that the court timeframes don't extend to the right and there aren't further delays. So, you know, you're easily, I guess, looking at £25,000 for potential liabilities for a landlord if the very worst happens. And I do stress if that's the very worst happens. But what can a landlord do to protect themselves against that then?
Yeah, I mean, it's a no-brainer. You must, if you're a landlord going forward, you must have rent and legal cover. There's no two ways about it. It's just one of those things that you have to do. Tenant circumstances change all the time. They can lose their job, they get divorced, a partner might die, and they go from being steady payers to having problems of their own. Life takes over and you're in arrears. So, you know, the cost is about £40 a month. You just need to have it, and that's it.
£40 versus £25,000. I think I know which one I would be gambling with there. Okay, that's clear. Thank you. And I guess, what about other grounds that might be relevant? For example, if the house, if you've got a tenant that's been there for a very long time and, it's at the stage now where there's a full, refurbishment required in the property, what can a landlord do in those circumstances?
Yeah, so a mandatory possession ground for redevelopment is there. You would need to prove that you couldn't work around your tenant, that you do need vacant possession to be able to do the work. And again, I keep coming back to this evidence. You've got to be able to document to the court, to evidence to the court that you have to make your tenant homeless before you can do what you need to do. So, if you've got to move a family member in, that's another reason that you can have as a mandatory ground. But again, you have to evidence it. And what they're trying to do is push the work onto the landlord. So can you come to an accommodation? Could you work something out with them yourselves before it even gets to court? And that's what they're trying to do. This is what this whole push is towards.
Interesting. Okay. Now, one of the other things that is important to a landlord, but is changing significantly, is to do with rent reviews. What, in simple terms, is happening with rent reviews, and how is that going to change under this new regime from the 1st of May next year?
So at the moment, we'll do a tenancy renewal once a year, and that is drawing up the new paperwork and doing a rent review in one go. So the structure will be there, but it's just going to change slightly. So you'll have heard us talking about Section 13 notices. So that's a new mechanism for increasing the rent. But actually, from our point of view as an agent, there's a lot more work going to be involved, because what we have to do is demonstrate and evidence, again, more evidence, that the rent that you're agreeing with your tenant is going to be market rent. So you need to provide documented evidence, market analysis for the area. We've got access as agents to the back end of Rightmove and other sort of portals. And as large letting agents in Oxfordshire, we know what market values are, and we can demonstrate that. So you would need to go to your tenant, you would need to say, this is what the market rent is, this is the mechanism by which we're going to do it, and we're going to give you 2 months' notice for that rent increase.
And so you've got this body of evidence that you've created with your letting agent, because they've got the only source of data, if you like, to say what rents are actually going for. And you present them this Section 13 notice, your rent is now going to be this in 2 months' time. What if they dispute that or don't agree with that decision?
Okay, so they can do that, and it will get then passed to the first tier tribunal, and they will then do a review of what has been offered to them. So is the rent being proposed market rent? They will then look at the evidence that the landlord or the agent has provided, and if the evidence is provided then backs up that rent increase, then they will support that rent increase and it will take place. What they won't do is backdate it. So if you want it from the 1st of January, the court backlog might mean that they won't actually see it for a couple of months. They might then give the tenant a month's grace to give them time to get the money together. So again, it's pushing it down the line. What they're trying to do is get the landlord, the agent, to speak to the tenant, negotiate that rent themselves. They don't want it to go to court.
Yeah.
So again, it's this skill of experience of negotiating with your tenant to try and get a rent increase, which we do day in, day out, and that's why we are good at getting the rent at a decent standard. Of
course, and if it takes 3 months for the tribunal to ratify that rent increase, then effectively they've been on the old rent for potentially 15 months, because you won't be able to do another rent review until 12 months after the new one has come in. Exactly. I think I explained that correctly. Yeah, good. So right.
Pushing it down the line.
And sort of turning that to a slightly different angle then, if we've got a tenant that in the past or currently wishes to pay up front, that is something that is going to change under this regime as well, isn't it?
Yeah, and this is affecting a lot of landlords, especially if you've got tenants from overseas or students, or maybe tenants with bad credit history. That going forward is an absolute no. Government has been very clear on that. Even if your tenant offers to pay that to you, advice we've received recently is don't accept that until it's proven in a court of law. Do not go there. It's as simple as that. The other thing that you have to remember is that when you're bringing a new tenancy on board, so your tenant pays their first month's rent to you before they move into the property, that is in theory rent in advance. So what you must be absolutely clear of is that your tenant has signed the tenancy agreement first before you accept that first month's rent, and then you can move them in. So there's a risk there.
That's cheeky. That's a really crucial point, that a lot of people won't have picked up on. So at the moment, you would never move a tenant in until they've at least paid the first month's rent, because you just wouldn't give them the keys. But now, under the Protection from Eviction Act, you'd have to give them the keys once they've enacted that tenancy agreement, even if they haven't paid in the very worst case scenario, but that's another case for rent legal, isn't it?
Rent legal, and obviously having an agent who has got processes in place to ensure that will come together. But that's where you can fall between the gaps if you're not careful. Yes,
cheeky. And then we're still going through a lot of renewals at the moment with tenants, even though this comes in 5 months' time. Why are we doing that? What's the point in that?
So tenancy renewals are still really, really important, because if you think about it, the only thing that's changing going forward is the terminology within a tenancy agreement. So at the moment you have an assured short-hold tenancy. It's going to be called an assured periodic tenancy, but the actual legal terms within that contract are still valid. The only bit that's changing is the time frame element.
Okay.
So you really need to make sure that your tenancy agreement is on the most up-to-date terms, and that you've got a rent review carried out now in the old system. Yeah,
so you're ready to go, and then you don't have to worry about it for, at least sort of 6-7 months under the new regime. Okay, that's clear. And I guess my last question for you is around the courts. Given the sort of volume of cases they're already dealing with, and they take criminal law as precedence, in terms of trying to deal with cases over civil cases, which is what we're talking about, aren't they simply going to be overwhelmed with the potential volume of possession cases and rent renewal cases and everything else?
Absolutely. It is a really big concern for us and landlords. They have acknowledged that is a problem. They've said they've got processes and mechanisms in place to resolve that. What they want to do is get landlords and tenants to sort stuff out themselves before it even gets to court. I think going down the line, maybe in 5 years' time, there may be online portals. Tenants can upload their evidence, landlords can upload their evidence. A judge can then make a decision. I think, that's what they're hoping for down the line. But our message today is make sure you've got rent and legal protection, so that if it has got to go to court, you're covered. Have evidence and documentation on absolutely everything you do. Negotiate, use the skill of your agent to get everything resolved before it gets to that place. So be on it, don't even get to court.
Brilliant, that's been really clear. Joy, thank you very much. As a hot off the press, we've got a bit of a gift for everyone, because we only got this today, but in fact this afternoon. But if you'd like to grab a copy of our new Renters' Rights Survival Guide, just click on the button that's just appeared on your screen now, and you'll be able to grab a copy of that survival guide that will take you through in detail a lot of things that you need to be considering and doing now to make sure that you are ready for this when it comes in on the 1st of May. And I'm just being joined by Grace from the Chinner office, who's the head of lettings there, and she's going to take us through a couple of the other key aspects of this legislation once you've had a chance to download a copy of that survival guide. So hopefully you're finding that now, and without further ado, we will start talking about pets and things with Grace, which is good. So let's start with pets, as that's the first one. Everyone loves something that's cuddly and fluffy, don't they? So
they do.
What does this legislation mean for landlords with regards to tenants being able to make a request for pets going forward?
So at the moment, I think we can both agree, a majority of landlords are always typically on the side of no rents and properties. I think about 8% of landlords currently say that they would allow pets in their rental property. Whereas we've got on the other end of the statistic, about 75% of tenants say they would like a pet, have one, want one in future. So what the government are looking to do is to make it so that tenants can have pets in properties. And if they can't, landlords will need to provide a reasonable reason as to why not. So in terms of things like your superior lease, I know a lot of our landlords that have got flats, leasehold properties, they're very nervous saying, well, the leaseholder said no pets. That remains in play. Nothing changes. But a tenant does have a right to request a pet as of 1st of May. And I think a lot of landlords will be pleasantly surprised that actually all pets don't destroy rental properties, and you tend to have a longer tenant in situ there.
Yeah, that's a really good point, actually, because we always talk about pets in in negative terms when
Yeah.
we're talking about this. And a lot of this stems back to when deposits were capped at 5 weeks rent.
That's correct.
And there used to be a pet deposit that was outlawed. And then when this legislation was first spoken about, not first spoken about, but more recently spoken about, they were talking about changing the Tenant Fees Act
Yeah.
to allow landlords to charge for insurance. That didn't happen, so they backtracked on that in the final version of the legislation. But pets aren't necessarily negative, are they? And as you've said, you can have a longer term tenancy, a more stable tenant, if they find a property that they and their pet are happy to live in. But ultimately, it's a landlord's property. They should have the right to decide. So, okay, if the superior lease says no, that's one. What other reasons are there that a landlord might reasonably refuse pets? Do we know anything else?
So if you've got, for instance, a 1-bedroom flat and you've got a tenant with 3 Dobermans, something like that, it could be seen that actually that's probably not quite going to be right for you. Same with landlords that have house multiple occupancy. If they've got a tenant in situ already that's got a severe pet allergy, again, probably not going to be quite right. So it's just about being reasonable. A majority of landlords, I think, will be, as I said earlier, very pleasantly surprised. I've seen tenants recently do very sweet little pet CVs with a photo of their pet, what they like to do. And again, you're getting a lot more tenants nowadays that work from home. And so therefore, pets aren't being left for long periods of time. We could ask that tenants take reasonable steps to ensure that, flea treatments are kept up to date, that element of it. So,
and ultimately, the protection is still there, I guess, from the inventory and the checkout.
Exactly.
There is still a mechanism there to say it was like this, it's now like this. They don't look like human bite marks in the kitchen door. Let's sort this out. So, okay. But I suppose ultimately, can a landlord say no to pets going forwards?
Not really, unless they have got a real reasonable, reason as to why not, and then tenants can look at doing sort of a tribunal side of things. So we really want to, from the offset, really get an idea with tenants of what is reasonable. And again, I think a lot of tenants that do live in smaller flats, studios, they don't typically have pets anyway.
Yeah.
So I think when you're looking at sort of 2-3 bedroom properties, as long as you've not got, say a lot of the old cottages where you've got the open gardens where pets could sort of roam free, then I think a lot of landlords are going to really see the benefits of tenants with pets.
Yeah, okay, fair enough. And I think moving on to discrimination, what does the new Act mean by discrimination? What's it talking about in the round when they mention discrimination?
So ultimately it's that blanket ban, as with pets, but with tenants with children, tenants in receipt of housing benefit. So again, we're looking at effectively not discriminating against those that have it. In terms of things like children, again, we need to look at overcrowding. So if you have got a 1-bedroom flat and you've got someone with 2-3 children, it's reasonable to say that's probably not suitable. Again, if you've got properties with, say, open staircases that landlords cannot do anything about, again, reasonable.
And I think, probably as Joy said, it's about documenting all of your answers, all of your evidence, all of your conversations, because when push comes to shove, if you can't demonstrate that you've had that reasonable conversation, then that's when you're going to land yourselves in hot water. If you can document everything and demonstrate that, then I'd like to think that would be reasonable and will stand good stead.
Anything in terms of mortgages, if there's any mortgage specifications about that, as of 1st of May, no longer exists.
So that's going.
That's going.
All right, interesting. And then property standards. I sort of introduced these beginning in the time frames. We're looking further ahead here. Where are we going with this? What do we mean with this?
Well, we don't know. It's going to be phase 3. So ultimately, we are looking more 2035. Again, skipping 36, going straight to 37. So we're looking at the decent home standards. We're looking at mould, mildew, condensation. I don't know any of my landlords that if they had a serious problem with damp would say, actually, I'm not going to do anything about it. So again, yes, there is going to be coming into documentation, 14 days to ensure things are done properly. But we're looking at phase 3. I think a big thing for landlords is going to be the minimum energy efficiency.
Yes.
And the EPCs going to a C. But again, we don't know. we're looking at 5 years' time.
We've seen deadlines come and go for
We
the
have,
energy
very much
performance
so.
certificates, haven't
Yes.
we? In the meantime, energy performance certificates have materially changed, and
That's
the way in
correct,
which they
yeah.
rate them has changed. If I had a pound for every time someone proposed a deadline, I wouldn't have to be sitting here this evening talking about the legislation. But where are we at the moment? To be really clear, where are we at the moment with minimum energy efficiency standards? What's the minimum rating, and when might it come in?
So at the moment, we don't know. A lot of my landlords are saying, well, what can I do now? What can I do to prevent that? And what we don't want to do is get to the deadline and we think, oh, actually, we want to put in new double glazing or anything like that. So a lot of my landlords personally are not delaying doing things, exploring the options of, okay, if I'm going to put in double glazing to increase my energy efficiency, then how much is that going to cost me? Right, every month I'm going to put across X amount of rent, so I'm not working under a financial pressure when it comes to it.
I think that's the sensible thing to do, isn't it? And of course, those landlords that are looking to buy more properties, well, you might as well future-proof that, because what we're talking about, and just to be clear, it is not legislated, it is not confirmed, but what they are talking about at the moment is a minimum of a C by 2030. But we've had dates come and go.
We have.
That is the latest current thinking on minimum energy efficiency standards.
And it's always, you're improving your property. When we now more than ever, I'm seeing tenants with the cost of living saying to people, what's the energy efficiency? So they're looking at the bills, and I think tenants very much are being more aware of how much properties are costing to run, with rents looking at going up as well.
Yep.
You're looking at affordability side of things. If you've got one property that hasn't got double glazing, one that has, well, naturally it's a no-brainer, isn't it? You're going to go for one that is going to cost you less per month. So,
absolutely.
But that being said, when it does come into play, it's not going to change overnight. You're not going to suddenly be expected to get your EPC straight up. I expect very much.
They're not, assuming that by 2030 actually happens, they're not going to turn around on New Year's Eve in 2029 and go, oh yes, this is coming in tomorrow, by the way. We are going to get notice.
Yes, so it's always a good idea. Keep an eye on your EPC. If it's coming to sort of the end of its life, get it renewed now, see what you can do, and think, actually, if I know if in 5 years' time I am going to have to put double glazing, change the boiler, well, I'd rather save a little bit each month now. Yeah,
plan ahead. But that sort of sword of Damocles isn't falling on Band D and Band E properties anytime soon.
No, nothing changing overnight. So it's all about being prepared, being aware of what's going on.
Wonderful.
That's it.
Grace, that's brilliant. Thank you. And for those of you that have a little bit of trouble sleeping, and that isn't the right introduction for the semi-tame accountant that's about to come and join me, it is to do with downloading our damp and mold guide. So we have created for your enjoyment a comprehensive damp and mold guide, which if you'd like to download a copy of that to keep a hold of, then that just explains more about AWAB's law and what it actually means. Obviously, it's in the rental sector at the moment, social rental sector. It is coming at some stage in the future for the private rental sector. And Toby will come and join us now to talk about tax and making tax digital and the budget. Toby, welcome. I'm being joined now by Toby from Windrush Business Services, a local accountancy firm, because when we ran the seminar earlier in the year, I foolishly thought I would introduce Making Tax Digital, and it was one of the most popular subjects for questions, which of course I wasn't qualified to answer, and I reached the limit of my knowledge on that very, very quickly. And so I'm delighted to be joined by an expert on all things tax this evening. So if we've got some questions and things, then Toby might be able to help. But I think, first of all, Toby, just by way of introduction, what does Making Tax Digital mean for landlords?
So the whole premise is that the government are trying to get their information on what tax receipts they're going to do, and they want to make that sooner and have more visibility and more sight of that. So Making Tax Digital is basically how you report everything to government and how often you have to do it. So Making Tax Digital, for people who are VAT registered, that came into play in 2022. They're just moving it into the...
So it's not new, but it's new for landlords
yes,
at different bands and thresholds. So basically, everyone's going to have to start doing this at some point, but it just depends how much additional income you have as to when you start having to do this. Is that right?
It's very much a when, not an if.
Yeah.
When it comes to doing it, the key things are, it comes into play from the new tax year next year, and that's at 50,000. The year after that, it's anyone who's got income over 30.
And that's all additional income, not just rental income that this matters for, or is it?
No, so it would be if you've got employment or you've got your own, self-employed business.
Yep.
It's the turnover from. It's basically all of it.
All of it. Okay, so if you've got some other income coming in as well, then very quickly you're going to find yourself in one of these income bands that's going to affect you.
It's fully important to note that it's not. If you're employed, that's not self-employed income.
Yeah.
So
Put that to one side.
Yes. So, but for someone who's got a self-employed trade and renting, then it comes into play. And
my understanding in the sort of most basic terms is, if you are someone, or if you're a landlord, hopefully you are already doing a tax return at the end of every year. But you'll go from, instead of having to do the sort of tax return at the end of every year, you'll now be doing effectively that, but every 3 months.
Yes, so the part of the MTD requirements is quarterly reporting. So, and also you have to be using Making Tax Digital compliant software. Now, there are, for those people that want to use Excel, you can get what's called bridging software. When we've looked at that in the past, for the cost and the clunkiness, it's just not worth it. So you just need to find a MTD compliant software. There are a fair number about, and if you've got an accountant, they can always advise you on which one they think would best suit you.
So I think probably the days of landlords doing their own accounting are becoming numbered, because if you need specialist software, it's going to be more expensive. Have you got any good news that you can tell people, or how can they make this go away?
Well, I think, as we said on the slide there, we've got joint ownership. So if you've got a couple of properties, but they're jointly owned with a spouse, then the income is halved. So between you need to be having 100,000 of rental income.
Oh yes, okay. So let me just explore that for a second. So we said that the average rent in Oxfordshire is actually £1,516, but I mentally will struggle with that right now. So let's say it's 1,500 quid. So that is £18,000 rental income per annum. Now I know you can take off agents' fees and things like that, but let's just say it's 18,000.
It's the turnover.
That's the turnover. So okay, right, thank you. But if the property is jointly owned 50-50, then actually you're only reporting on £9,000 of that each. Is that right? Yes, good. Okay.
But I think as rents go up in 2027, when it becomes 20,000, that's where it's not a if, it's a when you're going to have to do it. What we've said to people, especially when it came to the VAT elements, and I'm going to give the same advice to all of my self-employed clients and any landlords. That's when you have to start doing it. You might as well start as soon as you can, because then you find out any problems and you've got it all running up smoothly for when you have to do it. Because we'll always find that there's a deadline. 3 months later, there's a load of headless chickens running around the place whilst trying to press buttons and fix things that don't work. So it's much easier just to get it done.
Yeah, okay. And I suppose a lot of landlords may already be working with an accountant, but if they don't, then I'm assuming it's something that you could help them with and make it go away in the nicest possible way.
Yeah, and it's something that we've spoken about, and we're quite happy to almost offer a service, as it were, because you guys would get, you know what the rental income is, what the expect, especially for those fully managed ones. So we can come up with packages and plans that would be able to make it go away, as it were.
So I think if we'll put all Toby's contact details in with the email that comes out after this. If anybody wants to explore that a bit further, then do by all means drop them a line. But I think we'll look at questions in a moment. So I've seen a few popping up, but before we do that, let's go on to our last subject. Thank goodness! What a way to end the budget, which was I almost want to say a little bit of an anticlimax in a good way for the property industry, because we'd had over 2 months worth of speculation and therefore disruption about the property market, because all sorts of mad ideas were being thrown around. And actually, we didn't see any changes to stamp duty. We didn't see any changes to local housing allowance, which will make it very difficult for those tenants in receipt of that. But what we did see, which will be a concern to our landlords, is that additional 2% tax rate on property income. So tell us a bit more about that.
Yeah, so that goes to, it's when Labour had their manifesto, they said we're not going to increase tax rates on working people. And since they've come into power and had a look at the state of the British finances, they now need to try and find a way to define what a working person is. And they're obviously fallen on the basis that if you're a landlord, when it comes to your rental property, you're not a working person, so therefore they can increase that tax rate.
And it's a tax on the turnover, not the profit for the landlord as well, isn't it?
No, so the tax rate will be on the income. So
on the income,
yes.
Yeah, specifically. Okay, and obviously it depends on which tax rate you're in. You just need to add 2% to that,
yeah.
And this affects those landlords that own those properties either jointly or privately, I should say. Whereas you still get hit if you're a company landlord, if you've incorporated as a limited company, because you'll get taxed the additional 2% because that's being applied to dividends. So we've got property tax at 2%, at dividends at 2%. So it doesn't matter how you take it out, you're going to get taxed at 2% or an additional 2% anyway.
So if it's a company, it's just the timing issue. If you own it, if it's not within that limited company, then it falls during the tax year in which you make it. And I think if there's any consolation, what they've done is they've just increased it by 2%. There was talk of bringing national insurance into it, and I think that probably would have made life more complicated and would have been a bigger hit.
Fair enough. And I think the last thing to just briefly mention, for anyone that's fortunate enough to live in a property that's valued in excess of £2 million, then the mansion tax, I think that's not the official name for it, but that's what we all call it, is going to see a higher rate council tax band applied from 2028. But we can cover that separately for those that are fortunate enough to be in that position. But that, I think, covers the meat of what we wanted to talk about tonight. But I'm going to ask you to stay put, because as you're here anyway, firstly, I've got one last poll, and while I have a quick look through the questions, because we've got over 20 questions in already, and so I'll have a look through those, but I have no doubt that some will be around tax and the like, and therefore it's really what answers we want for that. But first of all, on the back of what we've seen tonight, how ready do you all feel for the Renters' Rights Act? And I'll have a quick review of the questions and see how we can help with answering some of them. Right, so Toby, I've started at the bottom because that's where the tax questions are. So from Oz, splitting the rent is great. Would that still make sense if both are high income earners?
So if both are high income earners, then you're both going to be paying 42%. I think that the splitting of it will depend on when you fall into the making tax digital thresholds. So you could be that. So in terms of the tax that you're going to pay on that income, there's no difference whether but if you're both high rate taxpayers, but it might be that you can move into making tax digital in 2027 rather than 2026.
Okay, clear, thank you. Beverly's asked about new local council tax charges for landlords. No, that wasn't one of the ones that made it into the final cut of the budget, but I know it's something that was spoken about, so pleased that we didn't see that. Oh, you might have got off lightly, Toby. I think that's it for hang on, do we have one more come in before I evict you and put our letting specialist in the seat? Oh, here we go. One last tax question, and then we'll bring the lettings team back. Will you have to itemize all the costs with the new software, or just give a total for the year like at the moment? Do we know the answer to that?
Well, part of the reason for making tax digital and using that compliance software is that they want you to put it all in to that system, and it's got and a top tip when you go that route is open a separate bank account, because you need to link your bank account to that Making Tax digital software. So at the moment, you can just put in, here's a lump sum, but I suspect that once MTD is up and running,
it's going to be a lot more detail that's likely to be required.
When you do that electronic submission, I mean, now with the VAT side where it's in 3 years, when you press that button, it sends the entire audit trail to HMRC. So it's cut down on inspections because they can already see. So,
Toby, that's brilliant. Thank you. Thanks for your input. And as I say, we'll put out your contact details with the recording. So anyone that's got some tax questions, then Toby's absolutely your man, because if you ask me, you'll get a terrible answer. And I'll ask the top lettings team to return to the floor and help me answer some of these complicated questions that have come flooding in, to see how many we can get through in the last 10 minutes we've got left. So our first question is from Charlotte. It's a student question. We don't do students, Charlotte. I let my property to students on a 12-month fixed-term contract. How will this impact the rental market to students if they can now leave early with 2 months' notice?
Yeah, I'm afraid we're not student experts. I know there's provision in the paperwork for some students' allowance. I can't tell you that, I'm afraid. I'd rather not say.
We've not focused on that in our office, Charlotte, because we don't specifically. We'll be able to find out for you and we'll get back to you, but I think we'll struggle with that one. Jeanette, are parkers tightening up their vetting procedures regarding prospective tenants? That's crucial. And yes, who's going to take that one?
I'll do that one. We've just moved over to a new provider for referencing called HomeLet. And I don't know if anybody came to the seminar in the summer, but they gave some really good information on their referencing, and we have linked with the referencing team. They now do the rent and legal protection, so they are linked together. One wants to be as good as the other. So yeah, referencing is key to successful tenancy.
And I think it's worth mentioning they don't want to pay out on the rent and legal policy because that will cost them a lot of money. As we explored, it's going to be £25,000 for a simple eviction. So bearing in mind they're the ones doing the referencing, you can be pretty sure they're doing a very thorough job of it to avoid having to make out paying on any claims unnecessarily. So yes, we are, and we will continue to do so. One from Peter. I'm concerned about rent arrears and their abuse. From what I understand, tenants need 3 months in arrears before you can start the eviction process, and they only need to reduce the arrears by a little bit to halt the process. What will be good strategies to manage rent arrears once the Renters' Rights Act is active?
Yeah, again, this is going back to having the rent and legal protection in place. You're right, 3 months rent arrears. By the time you've given your 4 weeks notice, they'll have probably paid a little bit off and they will no longer be in arrears. You go back to starting again. You've got the discretionary grounds, which mean that if they're persistently doing that over a long period of time, you can go to the court and get possession on that basis. But again, you're going to have to evidence and document that to say that you've tried to negotiate with your tenant to get them back on track, and that it has happened multiple times. So if you have a good rent and legal policy, they will pay out straight away. You won't have to wait for that whole process. And that's the key. Some landlords think they can get a really cheap rent and legal policy. That's because that policy isn't paying out at that initial stage of rent arrears.
Fair enough. Thank you, Joy. Simon's asked, if a tenant chooses to leave and gives notice, there is no restriction and you can mark it to sell straight away, correct? Yes, and in fact, Simon, I'd say it's better than that. Well, yes, you can start to market as soon as they give that notice. You don't have to wait until they're out. Obviously, you won't be able to proceed beyond exchange of contracts until you've got vacant possession. But yes, that is absolutely fine. Then a hypothetical question, asking for a friend. If I have a tenant who is paying well below market value and their last rent review was the 1st of September 2025, and I want to get the rent up to market value or just below, can I do this before the 1st of May 2026, less than 1 year from the last review, to beat the new law implementation, or do I have to wait until the 12 months and can't increase below the September 2026 rates?
I think they know the answer to that. Yeah.
Nice try.
Once a year.
Once a year.
Once a year.
But yes, you know, anyone that's been to any of our seminars or webinars will know we've been banging the drum. Get your rents to market rates before this comes in. End of.
Yeah. Tell your friend no.
Claire has asked, would the insurance pay the difference between a disputed evidence-based rent rise and the current rent whilst the dispute is ongoing?
No, I wouldn't have thought so.
No, the insurance is there to do with the non-payment of rent or the eviction costs, not if there is a dispute between what is being proposed and what is actually being paid, unless they cease paying the rent. If the Section 13 notice goes through and they don't pay the new rent, then yes, absolutely, I would expect it to come in at that point, but not while somebody's arguing about whether or not they should pay a bit more rent, I'm afraid, Claire. The survival guide link is not working. Right, leave that with me. I will send it out. Apologies for that. I will send out the survival guide in 24 hours along with the recording. So sorry about that. Don't know why that's not working, but we will fix it for you. Deborah has asked, if a landlord wants to themselves move into a property that they currently rent. So I think it's about, you know, can they move back into a house that they rent? And Jason's miles away, so I will answer on his behalf. Yes, what ground is that one? Is that ground 1? 1A is to sell. Don't know. Anyway, yes, it's one of the new grounds, and yes, you can absolutely do that. The same rule will apply in that it'll need to be a minimum of a 12-month tenancy, 12 being 8 plus 4. So they've been in residence for 8 months, given 4 months notice at the 8-month point.
Can I just point out, if you have renewed a tenancy, that's actually restarting the clock, and that's something that was changed slightly in the latest legislation. So they consider that as a new tenancy, so the clock does restart at that point.
Pets. I knew we'd get pets. Somebody else called Brendan. Excellent. Top bloke. Regarding pets, can you still include a make good clause at the end of the tenancy?
Yeah, so in terms of how we do inventories, check-ins, check-outs, we always want tenants to put properties back the way that they found it when they moved in. So apart from allowing for wear and tear, then yes, we would expect properties to come back just the way that we found them.
Marvellous, thank you. And Maria has asked, if your tenant's AST is still ongoing in May, do we need to redo the contract at that point, or would it automatically revert to the new system with no end date?
I can do that one. So what will happen is that all fixed term tenancies overnight will become periodic tenancies. What will happen is a supplementary information sheet, which is going to be produced by the government, will need to be issued to every single tenant in the country. So that's going to be produced April time, and you've got a 2-month window approximately to issue that to your tenants. So obviously we're going to have a lot of work to do. No annual leave at Parker's in May.
Okay, great. Consider yourselves on notice. Deborah's come back with, if a landlord wants to move into a property they rent out, is this grounds for repossession? Yes, I think we've answered that. What if the landlord wants a family member to become the tenant of rental property that has another tenant? Can the non-family member tenant be evicted for this reason? Just making sure.
As a tenant, yeah.
What's a family? So if we're moving out one tenant who's not a family member and moving in a new tenant who is a family member, that's absolutely fine. Again, still the 8+4 rule will apply. But yes, and the definition of family member is quite broad. I don't think it's second cousin thrice removed, but it is not far off that. It is quite a broad definition of what a family member is. And I think we're coming towards the bottom. We've got a couple that snuck in at the last moment. Let's have a look. Will the new from Nick, sorry, will the new regulations have unintended consequences for tenants? Higher rents or difficulty in obtaining a tenancy? Oh, Nick, that's a killer question. It wasn't even a plant. Go on, who wants to go first?
So will they ultimately
higher rents?
I think rents will go up. Yes.
Short and sweet, absolutely.
I think rents
there's a key reason rents will go up is because tenants cannot offer over the asking rent, and the only way you can ensure you are not under letting your property is to almost not ask a ridiculous rent, but to overvalue it, because then tenants are always underbidding. And what consequences I have? It's going to push rents up. it's a no-brainer. It's not even an unintended consequence. It's blatantly obvious. But difficulty in obtaining a tenancy, yes. And I think that refers to non-upfront payments, because who do we see that typically wants to pay up front?
Students, overseas, people who have got a lot of money.
Yeah, overseas tenants,
Don't
they're
have any credit
relocating, and they won't be able to pay their rent up front. So yes, the answer to both of your questions, Nick, is yes and yes. And lastly, Patrick, I have a property with solid brick walls, so damp it's an issue, and I want to install external insulation, but I have been refused planning. What can I do? Right. So I think that's quite a specific question. There are two ways I would tackle that one, Patrick, and I'm just going to give generic answers, but I'm happy to pick this up with you offline later. On the damp and mold one, that's not in for the private rental sector yet, but there will be AWAB style issues and timeframes to adhere to around that. But looking at it from an energy performance certificate issue, minimum energy efficiency standards, then because you've been refused planning to do something that is going to materially affect the energy performance certificate, you are probably going to be able to qualify for an exemption certificate, which would allow you to rent out the property for 5 years if it doesn't meet minimum standard. I appreciate you've asked more of a damp question than an EPC question, but it's kind of linked. So there are two ways to tackle that, but it depends around the specific property. Look at that, 1 minute over. Beautiful. I said an hour. I promised you an hour. My final thing to say is save the date. We'd love to welcome you to Witney to come and have a glass of wine with us and hear what's actually going on shortly before this comes live, because there will be changes, there will be more detail, we will know more, and we want to share that with you. So 14th of April, we'll be up at the Corn Exchange. We'll send out obviously emails and things around before, but that evening we will be back in the Corn Exchange to share all that with you. But on that bombshell, thank you all for joining us and for your attention, and we will send out everything along with a working link for the download survival guide in 24 hours time. Thank you very much indeed.